mediation, which is, I don't think there's any need to talk about it much more. We want to talk about one other thing that you may hear about, which is called collaborative divorce. Collaborative divorce is collaborative divorce SM, which is sort of like an American, what's in your book actually, so it's just like a trademark kind of.
See the TM? SM says means service mark.
But that's a relief to me. Was that a masochistic you thought it was? Some lines just work that way. Anyway, what it is that you join a group that is not just lawyers, but that's therapists, accountants, business evaluators, communication coaches,
Child development specialist.
and so that when you are engaging someone in the group, then you are essentially engaging a team. Now, different rules apply in different of these practice groups, but one of the problems that we saw for us is that in our community, we did not see this as a realistic choice because frankly, there were some of the particularly the counselors we wouldn't want to have in our group. No, but anyway, it's a question of expense here. You cannot. People already are concerned in many cases about having to hire 2 lawyers and pay for 2 lawyers when we just want to settle. We just need someone to write this up for us, you know. And we're trying to encourage them that they should each have a lawyer and that we should talk for quite a while rather than just sign something that they right away. We just don't think that the expense warrants having all these folks in. So we deal with experts in a different way.
So the collaborative divorce SM model, service mark model, is one where it always involves for every file where there are children, 2 lawyers, a communication coach for each client, a financial planner, and a child development specialist. And the only difference, if there were no children, would be you'd lose the child development specialist. But your 4-way meetings are not 4-way meetings. They're as a communication coach present. And
what do they do, the communication coach?
Their role is to do active communication assistance in terms of clients expressing themselves, meeting with clients between the 4-way meetings, the settlement meetings, to assist them with in personal relationship problems, communication skills, doing the active teaching. And, you know, having done this now for a while, I can see that would be helpful. But, I mean, it's prohibitively expensive if you're looking at paying anywhere between, typically for those kinds of people, $60 to $120, $150 an hour for each of you to have a communication coach, to have a child development specialist there for all of your meetings involving the parenting issues, to have a financial planner there for all of your budget, and that clients will work with this neutral expert outside the 4-way, but the person will be in the 4-way whenever you're doing those issues. So the price tags are enormous for something that's that comprehensive. I mean, wonderful if we have the Hollywood divorce or the multimillionaire lottery winners or whatever, but A, we don't have that range of professionals in Medicine Hat because we're a small community, and B, it's really expensive.
Do you ever use any one of those experts?
Yes, and
do
we'll
you use them in your meetings or always outside?
both, and we'll talk about that when we get to the expert section of the
In fairness to the collaborative divorce people, not all the groups require you to have all these, but what they do is that if you need one, then they've got someone that's already in their group that they call on. We do it a little bit differently. They're not members of our group, but they are people who adhere to
our principles,
understand it, they've had some education about it, but they haven't had to take the collaborative training. The people who are non-lawyers who are in the collaborative divorce SM model have all had the same training essentially that the lawyers have had. And so we've not required that.
It's the model that's kind of been adopted in Winnipeg, in Vancouver, and in Toronto. And one of the problems with it as well is it's maybe a late stage of dealing with collaborative law, but it sets up a lot of impediments for growth. It makes it very, very difficult. You have to spend 10 or 12 days of training to be qualified to even participate in this, and most lawyers aren't prepared to make that commitment. So it's what's happening in a lot of places. It's stalled.
Yeah, and most of our clients don't have those kinds of resources. We don't live in, you know, Silicon Valley South or Hollywood or wherever. I mean, occasionally I have some nice rich files, but they're not the norm. Okay, so if I can just quickly refer you to in the materials, under 4.4, under tab 4 I should say, the definitive article that is so well written on what collaborative law is, and what it is and why family law attorneys need to know about it. And it's not just applicable obviously to family law attorneys, but that's where it began. The definitive article is Pauline Tesser's article under the first one at tab 4, and it is, she writes well, she writes clearly, it's an interesting article, and it's still regarded as the lead article in the area, and I would commend it to your reading. There's another series of articles on making the paradigm shift, talking about interests versus rights. Stu Webb's material is excellent. Chip Rose is a really good guy on paradigm shift.
Chip Rose uses what I think is the best description of what collaborative law is, and he compares discovering collaborative law to being in the Wizard of Oz when Toto pulls back the screen on the Wizard of Oz to reveal who the wizard really is. That's the litigation system, and once you start looking at the litigation system and looking at enhanced settlement processes and negotiation, all of a sudden the litigation system loses all of its allure, and it, in a way, becomes a bit of a fraud, because if we're settling 98% of our cases anyway, but we're using this process, very elaborate process. But in my mind, Chip Rose's analogy is, I think, the best one I've read, and I think it's quite accurate.
So what is collaborative law anyway? What is this process, and how does it work? Its theory, its foundation is an interest-based negotiation, not a rights-based model. What are the client's interests? What is important to the clients and why? What are the problems that they need to solve? And that is the beginning of the process. The beginning of the process goes like this. Client walks into your office for an initial interview. You've never met the client before. They tell their story. You have an initial interview with them, which is about what are the choices that your client has in order how to solve their problems, not what the solutions will look like, not consisting of much other than general legal advice, but what are the choices that your client has in terms of how they would like to solve their problems. Those choices consist of do-it-yourself, collaborative process, mediation process, going to court. Those are the basic 4 options that every client has with every problem. And we're going to go through each of these stages that I'm outlining right now, and we're going to demonstrate them. We're going to talk about them, demonstrate them, and you're going to role play them. So again, initial interview, tell the story. Initial interview goes through the choices that the client has. If the client is interested in collaborative process, collaborative law, then how do we enroll the other side to the dispute in the process? We're going to talk about that. The process then consists of a second meeting once both clients are on board, each lawyer preparing their client for the first 4-way meeting. That typically takes about an hour of time with the client. So we're looking at initial interviews taking an hour to an hour and a half. Both clients being enrolled in the process, and we'll talk about how that happens. A preparation meeting, briefing the client in preparation for the first 4-way of approximately an hour. A lawyer-lawyer meeting being next on the next stage of the process. 2 lawyers meeting together, not to talk about positions, not to talk about rights, but to discuss how to make the first 4-way meeting as effective as possible, what the agenda will be, how they will manage any things that might be impediments to the process, to discuss process. So a lawyer-lawyer meeting which typically takes anywhere from 10 or 15 minutes if you've had lots of files with that lawyer, to upwards of an hour if you've never had a file with that lawyer. And we'll talk about that range as well in the lawyer-lawyer meetings. Next stage of the process is first 4-way meeting. What happens there? What's the agenda? How does it work? And typically the agenda for the first 4-way meeting always is drawing out, well, first of all, the very first thing we do is we spend 45 minutes to an hour going through the collaborative law contract. And the foundation to the collaborative law process is a four-way contract signed by two lawyers and two clients, which says we're agreeing not to go to court. We're going to stay out of the court process to solve our problems. We will not use threats of court to solve the problems. So no language will be, no behavior or language which is, if you don't give me what I want, I'll take you to court. And that if the process breaks down, both lawyers and any lawyers in their firm are off the file, and the clients look and hire two trial lawyers. That we are hired and we have a limited retainer only as settlement lawyers. And that if the settlement process breaks down, we're done. So those are the two fundamentals of the collaborative law contract. An agreement to stay out of court and use interest-based negotiation techniques to get to a settlement. And if it fails, you're done.
What about any confidentiality or information released during those meetings? Is there anything about that in terms of
Disclosure?
Yeah.
Yes, and if I can put you off a little bit, we will get to disclosure and issues around confidentiality and privilege. We'll spend some time on that.
One of the interesting things too about this is you are doing something in this that we've never done before, which is you're surrendering power to the other lawyer, because the other lawyer in effect can force you off the file, and vice versa. So by doing and signing the collaborative law contract, you're making or involved with an act of trust with the other lawyer that I'll give it a try if you do. And there's a very powerful type of disincentive for people to not play by the rules, not to follow the box. If you're a lawyer, if the other lawyer, if your concern is whether they will follow the rules, well, if they don't, they lose the file. And if they do that
fail.
consistently, they will not be practicing collaborative law. So it's quite a leap, but it's a leap that's well
sign
worth
that
it,
contract.
because it's an act of trust, that I trust the other lawyer that they're going to do this, and I'm also surrendering my power over the process. I've surrendered my ability to take it to court.
Right.
I think, sorry, if someone was going to though ask you in a nutshell what's collaborative law, then two things are, I put them a little bit differently. One is you're going to do it cooperatively, not adversarially, and that you're going to agree not to use the court process and beyond the file.
If it fails,
That's it.
you're done.
It's as simple as that.
That's the nub of the collaborative process. The four-way meeting spends 45 minutes to an hour going through the contract that defines the structure. That's in the materials. The four-way meetings always have the same first meeting agenda, which is go through the contract, 45 minutes to an hour. Draw out what's important to the clients, which is their interests. That typically takes a half an hour, 45 minutes. From there, we move to what do we need to talk about? What do you want to talk about? That's the issues. We move then into fact gathering for pressing problems only at that first meeting. Pressing problems might be in a family situation, if dad hasn't seen the kids for 3 weeks, and it's 3 weeks till the next meeting or 2 weeks till the next four-way meeting. What's it going to look like for that next 2 to 3 week period? Those are pressing issues that we deal with, and we try to deal with at the first four-way meeting. Pressing issues which the lawyers have already had an opportunity to know what the pressing issues might well be for that meeting, and share thoughts, not about how they might be solved, but about how they might use the process. So pressing issues are dealt with at the first four-way meeting, and then an agenda is built for the next four-way meeting. Homework is assigned for the next four-way meeting. Dates, next four-way meetings, if they're not already booked, are scheduled. And that takes about 2 to 2.5 hours, and you're done. And that's all that's accomplished at the first four-way meeting typically. Subsequent four-way meetings look much the same. The overall process of doing your business is done in the four-way meetings. And the meetings, the process gathers facts first. Once you've identified interests and issues, it's fact gathering first, common facts on all issues, whether it's parenting, whether it's money, whether it's assets, whatever it is, common fact gathering. Choice development next, maximizing with the 4 people in the room, creating all of the options that could possibly be created from soup to nuts, from extreme to ridiculous to the whole ball of wax, choice development, and only at the very last entering into negotiations. And you can see how, from that quick description, that the front end of this process is very heavy on time and investment of finding interests, identifying problems, gathering facts, creating choices. That takes a long time. The negotiations themselves typically happen very quickly because both clients are then negotiating from interests that they understand, and our job is to help them articulate the why behind their interests, why something's important to them, in a rational fashion that a reasonable person can understand. They've gathered common information and common facts. We've maximized their choices. We've expanded the pie, perhaps, that can be divided. That's another way of thinking. And the negotiation then happens very quickly.
Expanding the pie, I think actually another way of explaining it is what Noel was talking about earlier, and that is that you come up with solutions, with ideas. Not when I say you, I mean you as a group. Ideally, them as a couple, or a former couple, can come up with solutions that you would never have thought of before, and that would never be available to you in the court process. So that's what we mean by expanding the pie.
So that is the collaborative process in a nutshell, and we're going to break it apart step by step and dissect each part of it and assist you with what happens and what to do when at each of those stages. What does fact gathering look like? What does the first meeting look like? What does the lawyer-lawyer meeting look like? What does the initial interview look like? We're going to go through each of those particular parts of it.
I think, though, it's not good enough to just have a checklist that you go through,
Right.
although that's very helpful. It's important to have skills. You have to know what happens if there's impasse, or how you're going to deal with a lot of this stuff. None of what we're going to talk about is strange to mediators. What we've just said about not getting to even developing choices until you've got all the information gathered, that's very typical mediation procedure, if you like, protocol. You gather information. Information is power. You know, it's very unusual relatively unusual for both parties to have exactly the same information about what the kids are into, or particularly about finances. You know, if there's a business, what it's worth, what the debt is, what the investments are. It's not uncommon, let's put it that way, to see that one person has a clue or is relatively clueless relative to the other person. So until that information is the same for both, it's impossible. How can people make choices under those circumstances? Yet they try to do it all the time.
Good decisions are based on good information. And so essential to this process near the front end is gathering good information, which is facts that both parties can agree to, both clients can agree to, and if they can't agree, choices about how they can get to a decision on common information. But before we launch into this, we want to spend some time on communication skills, because fundamental to this process is the idea that the only thing we drive as lawyers in collaborative law, the only thing we drive is the process. We are not in charge of anything other than the process. The clients control the timing. Because clients control the timing and clients control what they want to talk about, they control what's important to them and what they want to talk about. They're in charge of what's important to them, not us. What we think should be important to them is not on the table. What they think is important is on the table. That's their interests. We don't control what problems they want to talk about. Clients identify what problems need solving, what they need assistance with. Sometimes it's 1 out of 3 problems. They manage to solve 2 and they need help with 1. Sometimes it's the whole kitchen sink they need help with. But clients control what they need to talk about. Clients control how often they like to meet. Clients therefore have more control over cost. And clients, and this is the big one, and it's true for mediators as well as for collaborative lawyers, clients control the solutions. Figuratively speaking, in a collaborative law meeting, each client has a yes and a no button. And we do not have a deal until both clients are pushing the yes button. And it isn't the lawyers that push the yes button. So the only thing in collaborative law that we do is we drive the bus. It's like a tour. If you can think of a tourist, if you're going to go from here to Calgary, and you're not familiar with Calgary or Medicine Hat or wherever you're going. If you're coming to Medicine Hat, we know the best ways to get places. You will decide, if you're the clients, what sites you want to see in Medicine Hat. Where do you want to go? Do you want to go see our famous teepee? Do you want to go and see our Medalta pottery, the things that we're known for? Well, we will know how we can accomplish getting you to those various venues in the most efficient fashion, avoiding the bumps on the road. But you will get to decide what you want to see, where you want to go. And that's all we do in collaborative process. And that is the hardest thing for lawyers. It's the hardest thing for me. It was the hardest thing for David. It's the hardest thing for the lawyers that we've worked with, is letting go of us controlling solutions, of telling people what to do. And if you've done mediation and if you've been an effective mediator, you will understand that already. So for those of us who, before we had mediation skills, that's what we're trained to do. We're trained to give advice, to analyze problems, to give legal advice, and to tell people or recommend to people what they should do. And we don't do that in collaborative law. And that is the biggest hurdle for us. It's not a hurdle for our clients, but it is a hurdle for us as lawyers because it's outside of our training box. It's a whole new set of skills to just drive the bus and not control the destination.
One of the things that Janice had said earlier that we would talk about was changing, going back a little bit, and that is the origins of what the origin of collaborative law was. And it can be sort of a date in time almost picked. It's a 1990, a specific date when...
January 1st, 1990.
Very good. I knew that someone would have that. A fellow by the name of Stu Webb. Webb is an interesting guy. He's 60s, I'd say.
Yeah, early 60s.
Now. And he was a pharmacist who went to law school a little bit later in life and practiced family law and became extremely frustrated with the adversarial system, and in fact had decided to leave law and had gone back to school to take a degree in psychology. And then came to the idea with Judge, he's now Judge anyway.
His partner then.
Who, and they decided that there was a better way to do this, and they came up with this idea of collaborative law, that they would in fact forswear the going to court.
Well, Stu says, how he articulates this is he said, I was taking psychology courses. I discovered very quickly in the first 2 courses I didn't want to be a psychologist. I like being a lawyer. So he said to himself, well, what is it that I don't like about law? What is it that I don't like about what I do? Maybe I should look at that before I abandon the profession. And he very quickly identified that what he didn't like was the war of affidavits and the court battles and the collateral damage that was done to the families that he worked with. That's what he didn't like. So he said, well, if I don't like that, how do I do it differently? And that's how he began the structure of collaborative law, which was fundamental to him was a contract to stay out of court and to get off the file, that he would not go to court with the clients. And how did he start it? He went to, when a client came into his office, he offered them the process choice, and there weren't other collaborative lawyers to have files with, and there was no structure, no formal practice guides, no protocols, no guidelines, which your association, if you join it, will have. He went and sat in the other lawyer's office and said, Joanne, I'm here, I'm acting for so-and-so, and I want you to know that I'd like to enter into an agreement with you formally that you and I will act for Bill and Mary, and that if this breaks down and we can't help them settle, that I'm done, I won't go to court for them, and I'd like to ask you to do the same thing. And that's how we started. And that was the essence of what he did, and it began to grow in Minneapolis and has now spread to a number of other practice groups. But it hasn't grown as rapidly as we've been able to grow it in Medicine Hat, or you've been able to grow it in Regina, and we'll talk about that.
But there are other groups, obviously, in the United States. Some of the places that are sort of
Hotbeds.
or relative hotbeds would be, of course, California.
San Jose.
Got all the latest stuff. And Cincinnati is another place that's fairly well launched.
Atlanta, Georgia is got a fairly active group.
But many of the groups are not active in the sense that there's high percentage of the files being done this way. It's still, for most places, a fairly boutique almost kind of way of practicing law.
So they were interested in us because it's become the norm in Medicine Hat. It's the dominant model. It's how the bulk of family law, and it's now moving into the other areas of dispute resolution in Medicine Hat. So of course for them it was, well, how did you get it there? Like, why is that different? How come we haven't been able to grow it? And in many ways, this is perhaps a gross generalization, but I think in some ways our Canadian culture perhaps lends us in terms of our thinking to being perhaps more open to some of the ideas that we're talking about. And they were quick to sort of pinpoint that idea. But one of the reasons, the major reasons, is that we have, I think, embraced all lawyers as possible lawyers to do this. All clients, this is offered to all clients. It's a skill that all lawyers could learn to do. It's a process that's available to all clients to choose, that it's not us that should choose, it's the clients. And that we as lawyers can do this and can get better at doing this if we share our skills as opposed to hoard them to ourselves. And that's one of the ways we've grown this model in Medicine Hat, is by giving away everything that we do best as lawyers and sharing it with each other, which is typically not what we do. If I have an edge up on you, Noel, if I have an edge up on you, Kirk, in a litigation model, I'm not going to share my practice, my efficiency secrets, my money-making secrets, my skills, my edge. In a litigation model, I'm holding it to myself. I'm going to try and do it better, faster, cheaper, offer a better service, and I'm going to compete with you straight up, heads on. And I'm not going to give away those skills. In a collaborative model, our group in Medicine Hat gives away everything.
To each other.
To each other in the group. And we beg, borrow, and steal widely from every other group. And we give away what we have to every other group, like yours. And the only qualification we have on what we share is that if you make it better, give it back. If you change it, it improves it. We want to see it back. So that is the fundamental shift in thinking, is that as a practice group of lawyers involving lawyers who are competing head-on with each other, we share our skills, we share our resources. Everything we do as a group, and we give it away, and that creates a tremendous work product. And you can see that working in the commercial marketplace. When you see Coke and Procter & Gamble, two very different companies, agreeing to form a joint venture and cross-market into each other's territories, and by doing that, creating much larger profit margins for each of their separate companies, recognizing that they have complementary interests, and that if they collaborate and cross-market, they'll each make more money. And that's essentially what we're doing as lawyers, is sharing our skills, sharing our talents, sharing everything we have so that we all do better, and we're all more skilled, and as a group of lawyers, we're all more effective.
But before we do anything about communication skills, I want to talk a little bit about a little bit more about the materials at tab 4. And Janice just referred to a couple, particularly the Tesla article. There's an article that she has written with one of her students. And this material from Webb, it's called additional materials, but essentially what it is a summary of his materials. This is a paper he gave last year at Washington, D.C., and this is essentially his training materials. and you will see that it talks a little bit about the history and so on, but from about page 6 on to 31, really, it talks about how you deal with the various problems that arise and the process. So that's all his process material. And then this is all for future reading, folks. From 32 to 36, essentially, he's got some information on promotion and so on. And Brad's going to talk to you about that tomorrow. There's a short 2-page article then from by Chip Rose. Chip Rose is the fellow who actually came to Medicine Hat and gave us our 2 days of collaborative family training. But Rose is, as you can see from the JD, he's a graduate lawyer who practiced law for some years but has not practiced for a number of years now.
He's a mediator.
He's a mediator. He's an extremely good mediator. He's very well known and
Very successful.
writes a lot of stuff, and he gives extremely good speaker. But he doesn't do any collaborative. He trains for collaborative training, but he doesn't do any collaborative law himself. He sticks to mediation because it's low overhead and so on. Doesn't want to go back to practicing law. So that's just a 2-page thing there. The next material in this is the material that we stole with permission from Pauline Tessler, who just to mention this. Pauline Tessler is the most academic or prolific, I guess, writer about collaborative law. She is a practitioner from California. She's written this book, Collaborative Law. It's a publication from last year by the American Bar Association, and my suggestion to you is that if you want it, that you should probably contact Brad or get somebody from your group to order it in bulk, because it's extremely expensive if you order it singly, but you can get a discount in bulk, and it's worth having and reading.
It's just excellent. It's cost gold, but it is gold in terms of information on the new box. It's somewhat weaker in terms of the actual skills, in terms of the actual precedents and whatnot that's in there, but it's really excellent in terms of understanding what you're doing and why you're doing it. It's just an excellent book, and I recommend it.
We certainly don't agree with everything that's in there, but Tessler does a lot of training in the States, particularly some in Canada, with web. And of the people that I know that do training anyway, it would be Webb, Tessler, Rose. There's others, but those are the ones that are
Those are the names.
The big guys. And Tessler, Pauline, for those of you who go to the National Family Law, anybody ever go to National Family Law?
It's in Kelowna this year.
Anyway, she's going to be there apparently on a panel.
With Brad.
And yeah, I understand, got on that panel too. Anyway, that's what I'm saying. And so
David wanted to say it's not what you know, it's who you know.
that's what I wanted to say. Actually, I wanted to say kiss all out of that. No, anyway, we're just jealous, envious. That so he's on, and there's a McDonald from Toronto, and Porter, I think, from Calgary. So that'll be on that. We're going to. Anyway, what she's got there is she's got a comparison between how the lawyers work in an adversarial and collaborative system, how what the client's expectations are of the lawyer in the two systems, how the case looks, how the lawyer works, both first of all with the client and then with other disciplines, and attitudes and how they're different. So it's kind of worth reading to kind of buff you up from time to time as to why you're doing it this particular way and what your attitude change ought to be. Your attitude might consider your attitude to be if you're trying to do it collaboratively. And of course, then it talks about how the lawyer works with the other attorney. The next article is out of the CBA National, and you'll see some, it's just a discussion of what's been going on in
Across the country.
across the country. It's a little bit dated now, it's almost a year old.
And the next item,
It's from the Harvard Business Review.
which I've got on an overhead here, which shows the differences in decision-making. And this is a general business model, so it is not only lawyers who are thinking in terms of decision-making in a different way, it is other business people. I think collaborative is probably one of the most overused words right now in the business community, in the business model of decision-making. And this just sets out the differences between the advocacy model of decision-making, positional bargaining, versus the inquiry method. And that's rights-based versus interest-based. You could substitute rights and interests on those two columns, and you'd have the same content. So this is not something that just lawyers are doing. This is something that business leaders, this is Harvard Business Review, this is topical, this is what's happening in the wider business community of business decision makers. They're just behind us.
That is a brief article on making the paradigm shift happen, and again, it's again Hessler, and I think this is stuff that you probably looked at in your previous, not that particular article, but in your previous training. So we want to talk now about the different ways of communication, and again, it's a comparison, and we will try to figure out why we're getting a very narrow image on the screen here, but anyway, you can see that there's different communication patterns that arise out of different processes. And clearly, if you're dealing directly, it's one-on-one, no problem. The problem, of course, that we've got is that this is broken down generally, or we wouldn't be involved in the first place.
People who have effective communication patterns and effective decision-making patterns in their marriages or in their relationships, people who can effectively make compromises and decisions, tend to stay married. We tend to see them when they can no longer effectively make decisions in a respectful fashion and make compromises that they can live with when that gets out of balance. So the reality of offering people the choice of making the decisions themselves as a viable alternative, it's really something that clients will say to you, like, what are you talking about? That
It's not viable for
It's not
most
viable for me.
So I want to start on this side, deal with the litigation patterns, and clearly there will still be some communication or between the mother and the father. We're going to assume in most of this stuff that there are kids, obviously. And they're each talking to their own lawyers. The lawyers talk to each other. The lawyers talk to the judge. Generally, these folks don't get to talk to the judge. These folks don't get to talk to the other person's client. And so you can...
It's tiered communication.
And if you've ever done that business about how where you whisper something in someone's ear and they whisper it to the next person,
That party game?
gets around to the end, doesn't have to go very far, 5 or 6 people, and it's seriously screwed up. Mediation we talked about earlier in terms of a couple of the difficulties here, but again, we've got the usually getting legal advice directly from the lawyer. Sometimes there's involvement of the lawyer, but it's with the mediator. But generally, the lawyer is still talking to the other lawyer, both before, during, and after. In many instances, the mediator is doing work, and these people are talking to the mediator. But depending on what the mediator does, sometimes the mediator just does up some not a formal legal agreement, and it goes back through these people to the lawyer, who then have to do the agreement and so on. So again, and even if the mediator is dealing directly with the lawyer, there's not all the room at the same time.
Lawyers typically do not participate in most occasions in a direct way with the mediation. There are exceptions, but typically lawyers are not involved in the day-to-day mediation process.
This is the way in which you have the communication patterns in a collaboration. All the players are are in the same place. Everybody has got an opportunity. And everybody's got an opportunity to speak to each other, so there's no misunderstanding. I'm sure you've had the experience in the litigation model where the client comes and says, when I talk to my spouse, she says that they're more than willing to resolve this on the basis that we've been talking about, but her lawyer won't let her. You know, her lawyer won't. I've heard that once, I've heard it a million times. And sometimes you actually knew that that was not something that the lawyer would in fact be saying, so that it was a slough off. And frankly, very unfair to the lawyers in many instances, because then that creates a lot of resentment in the first client's attitude to lawyers, for one thing. Figures that the lawyer's screwing up her chance to have this thing resolved, when in fact it's really not that at all. And so there's no misunderstanding here.
This creates effective, you can see that it's effective six-way communication that is checked out and can be checked out, and it enables itself to be checked out amongst all the participants. So that if Noel and I are the two lawyers and Ron and Kirk are the clients in any dispute, we have a way to check out effectively whether what Ron is saying or Kirk is saying is whether we each understand it, because there's effective six-way communication going. When we go to court, we're spin doctors. Our clients tell us their version of reality. We spin it in an affidavit, and we go and spin it to a judge, right? I mean, that's what we do. And we have the war of affidavits. And how often do we find that if we can get out of that and sit down and talk with the other lawyer and client, that the spin changes? That we've spun what our clients has told us, but that's our client's perception of reality in a particularly perhaps bad moment, vulnerable moment. They're angry, bitter, upset, jealous, whatever. And we spin that and take it off in this direction. And the other lawyer spins their client's sort of least functioning emotions, or most, when they're at their worst state, spins it in this direction, and it's polarized. That happens very easily in the court process. In the collaborative process, we take that opportunity of spinning away because it's able to be checked, and we create an effective way to do that so that everybody gets the same common information, both lawyers, both clients.
What I want to talk about is the material, some of the material that's behind tab number 5, and I particularly want to talk about two of the materials in there. They're both by Rose, and one is called Process Anchors, and the other is Fundamental Truths About Conflict and Interpersonal Relationships. One of the things you'll find in dealing with clients, and this is true whether you're interviewing them in your own office in a litigation, you're doing mediation, or collaboration, is that you find invariably that what your client wants to do is change the other person. You know, they don't like something about what the other person believes or does, or what their values. And I think that we do a disservice to our clients when we don't deal with that right away. And you can do this in a number of ways, but obviously one of them is, how much success have you had in the 15, 25 months, whatever, and how long you've been married, in changing this? The answer is, I haven't had much luck. That's why we're here. What makes you think that now that you're not together, you're going to be able to change what they believe, do, whatever? And if you can disabuse them of that this process, any of these processes, have an opportunity to change these things. You're not going to change what the other person believes.
Or what they think is important.
So that
You can't do that.
and you know, logic dictates, just looking at this fundamental truths about conflict and interpersonal relationships. No one has the ability to change the perspective, interest, or belief of the other party in any way that is predictable or desirable, so it obviously isn't logic that keeps us trying. We know, too, that if you're going to get into negotiations or discussions and you criticize or blame or accuse the other party, that you're not going to be heard.
Can you think of any problem that you know of that has ever been solved by blaming, by fault finding?
And so that's an opportunity to tell them, and you'll see in some of the materials we've got a little handout for them, to tell them about I statements and about using, always trying to make a point by saying, I am unhappy when, as opposed to when, you screwed up by doing such and such. I'm unhappy when you call me a slut, or whatever.
Common problem, David.
But you're just not going to be effective if you're directly critical, because the other person then immediately hears the criticism, the level of anxiety or anger or whatever goes up, and they're not going to hear what the point that you're trying to make anyway. They're going to hear you're attacking me, and therefore not very effective.
These are basic communication skills, which we as lawyers need to, first of all, learn, and then role model, and expect of our clients by giving them directive information, which is in binder number 2, about what those communication skills are and how they work. It's done in your Parenting After Divorce course. It's done in ours in Alberta. And so these are tools that we're going to spend a little bit of time on, because they're tools that you need in order to do collaborative law effectively.
I'm not going to read all of these items, but I think number 7 is incredibly important. You've got that article, but I'll deal with it anyway. In a collaborative negotiation, one cannot possibly obtain his or her best possible outcome without the other party also achieving the best outcome possible. And this is the problem, I think, with people who negotiate from positions. I know what I want, and this is what I have to have. Well, that's great, but do you think the other person is, think that's realistic from the other person's perspective? No. So how are you going to, what is really important to you, and how are you going to accomplish as much of that as you possibly can? Well, I can do that by making sure I accommodate what the other person also thinks is important. Okay? So what we want to accomplish, so it's very easy to explain. If you find something acceptable to you, but you know that it's unacceptable to the other party, how are you going to get what you want? You're not. So you have to tailor what you want to get into a range of what is acceptable to the other party. Now that doesn't mean that you necessarily have to give up what is most important to you. You may be able to accomplish it by giving something else in another area.
It isn't as important to you.
Something that's not important to you, but is very important to the other person. Now you may have lived with that person for a very long time, and you might not know exactly what that is. And so it's extremely important that you listen to what that other person says is important to them. And by listening to them talk and letting them talk and making sure that all of those things that they think are important are out on the table, that's how you can determine what you can give in order to get what you want. But you're not going to get anything close to what you want unless you're prepared to give something to the other side.
And clients understand very clearly that client A can't have their best deal with client B unless client B gets their best deal too. I mean, clients get that. They understand that fundamental truth about negotiation. They won't both push, I can live with this, this is acceptable to me. They won't both push the yes button until they are each achieving their best deal. It's not doable. If one person overreaches, it's not going to be acceptable to the other person.
Another one that we want to emphasize, I think, here is that, and this goes back to the kumbaya comment, this is, we don't cooperate and collaborate because it's the right thing to do, because we'll, be treated better when we get to heaven or whatever it is. It is, in fact, because it's the effective way to accomplish and maximize your self-interest. So this is not, you're a better person, client, if you're a nice person in this meeting.
This is not about values.
It's not about that at all. It's about you will be more effective. You will be more likely to accomplish what you want.
Your goal.
Your goals, and particularly in the bigger picture of goals, if you do it this way. It's a better way of solving your problem.
if you tell your client to behave nice at the meeting, and over the past 5 years, they don't behave nice, the other client may start thinking, well, they're just putting on a show. So you have to do it in light of the fact that people have a certain communication pattern. So telling our clients to change at the meetings, behave differently, we can encourage that. We can't tell them to be people other than they really are, or the other client will start going, it's a fraud. He doesn't offer me coffee at home. Why should he be offering me coffee here?
Another area of this, I wanted to also touch on these process anchors. This is another Rose article, and again, this is material that you can review yourselves and then review with your clients, and always can go back to these things. If people are being ineffective, you can go back and deal with these. So process anchor number 1, recognize the futility of arguing. That's pretty self-evident, I think. But you want to emphasize then, when you're discussing, you want to emphasize their interests. You can understand their beliefs. You don't have to accept them. But you should understand and recognize their interests.
Listening and understanding does not mean agreeing. And we forget that on a regular basis, and often our clients never do that.
Everybody has different process needs, and you have to respect the process needs of the other person as well. Every person has to go through their own development of the issues, their evaluation of options, and determination of needs. The more prepared to negotiate each party is, or both parties, the more successful the outcome or agreement will be.
But that's also really important because even though you and the other lawyer, who are the team of settlement lawyers in the room, even though the two of you may objectively, because this is the umpteenth dozen file you've had that has something like this on it, even though you think you know how to get from beginning to end and what the solutions might be, that isn't what your clients need. What they need is the ability to move through that process in a way that meets their needs, and to move through those interests, issues, facts, choices, negotiation, in a process that meets what they want to do, that they have control over, that meets their needs.
And just on this, the last sentence in that number 2 says, make it safe for the other to say what needs to be said. There are all kinds of occasions when people can be subjected to attack, if you like, or be very nervous about saying things. One of the areas is in the collection of information. One person says, well, I'm not really sure about the value of this car, or I'm not really sure about the value of the house. And the other person jumps all over them and says, well, you should know better, da-da-da-da. Obviously that's not acceptable at all, because you want to be sure that everyone is, in fact, totally comfortable with the level of information that they've got. So you'd immediately intervene in that and normalize or justify, if you like, or defend the need for the process to work. That is, for the individual who's saying, I'm not sure about this, to be able to be assured. And you do this in a number of ways. Let's take the example of the value of the car. I don't accept, or I'm not sure that what you're suggesting, husband, is the value of this car that I've got is right, or the car that you've got is right. And then you would go through and you would let them pick ways of how they could be satisfied. So you actually deal generally with the person who was not sure about the value of the car. What would it take, Sally, to have you satisfied? What would make you feel better? And let them develop a bunch of options.
What information do you need?
Yeah. And there might be, this is where lawyers can suggest things, but shouldn't be the first to suggest. So and obviously with cars we already know, there's the black book, the gold book, there's taking it in and having it written up by somebody. There's different ways of doing it. And then you turn to the other person and say, would you be prepared to do that? And of course, says, no, I don't want to do that. I know what the car's worth, and she should know too, for example. And then you just deal with it on the basis of process. Do you understand it? if we are not going to, until Sally is comfortable with this, then we're going to have very great difficulty in being able to move forward in terms of making any decisions about the car or about values and so on. So that's one example, for example. The other is in the developing of options. When you get to options, you want to be sure that people are very, very comfortable with coming up with something that might be a little off the wall. They want to be able to say, if I did this, would you be prepared to do something like B? Without being attacked for that. And you do this by really making it extremely clear that we're going to pick all kinds of options. And we might purposely pick a really crazy one that's
Bizarre.
and write it up as an option, so that they understand that it's okay to put up stuff, even maybe get a few laughs out of some of it, even, from time to time. But out of that, Janice, is you can develop some really interesting choices. The other way you make it safe in that circumstance, of course, is that, and this goes back to disclosure and so on, communications, is that what goes on in the room is without prejudice. By the terms of the contract, it's without prejudice until you have agreements. And you can have interim agreements which may not be without prejudice, but the development of choices is without prejudice. So you cannot see if the process breaks down in an affidavit. Well, in the collaboration, she suggested that she would do this. So those are a couple of ways in which you can make it safe, if you like, for people to participate. And of course, it goes without saying that you had to set up your physical arrangements in such a way that they're physically safe. And you also, of course, have made it very clear that behavior that interferes with people participating. We had so last night there was an example of a case where a chap came into the meeting and only one of the lawyers was present. He went up and gave his wife a big kiss and then
She resented
stared
it.
at this person throughout, sort of goo-goo eyes throughout the process when the one lawyer had his back turned and so on. So this was an interference, if you like, with the ability to. This was not an example that we had, by the way. This was from your group or your bigger group. This interfered with the ability of the second person, the wife in that instance, to participate effectively. And so clearly the lawyers would have an obligation, because it's the process that they're protecting the integrity of, to make it safe and comfortable for everybody, would have to intervene in that respect and deal with that. We can talk about how another time. I want to carry on with this just a little bit. Speak for yourself, use I statements. I've made some reference to that before, and I'm not going to spend any more time on it.
Is it a nice statement to say, I think you're wrong?
I suppose,
Not really.
but it's
There is in the materials under under tab 6, number C, handout for clients called.
that's binder 2, right?
Binder number 2, tab 6. Item number C, it's called effective communication skills. And that's the cheat sheet for you as lawyers and for your clients on effective communication skills. I messages. There are 4 kinds of I messages. They're laid out there. There's examples of each one. And that's something that our group has developed and that we use as a handout for clients, and we expect lawyers to follow as well.
See, you're right. It is a nice statement. I feel you're wrong, but it's not as effective as saying, I feel it's worth using the example of, I feel it's worth closer to. Now, the implied message is, I think you're wrong, but you're being positive in saying that this is my opinion with regards to that matter. And that leads nicely into number 4, which is avoid language about the other that is critical, judgmental, accusatory, blame-oriented, sarcastic, or inflammatory. And again, in your coaching, if you like, of your client, you simply ask them, how well do you respond to this kind of language?
How do you like it when people blame, name call, etc. you? Clients will always tell you that they don't like that it's not effective for problem solving. And then we will ask them, would you like to be effective in this process? Would you like this to work as well as possible? What's the client going to say? Yes, I want to be effective. Who's going to say, no, I want to spend more money and be ineffective? They're not going to say that. And then we invite them that if you would like to be effective and we note that you're not being effective, is it okay if we let you know that you're not being effective? We get permission from them up front in the briefing meeting that if they're not being effective, that how we will let them know that they're not being effective, because they've already said they want to be effective, because we've elicited that through questioning from them.
We usually also on that, ask for permission for the other lawyer to also, if the other lawyer feels that you're not being effective, would that be all right for that lawyer to do it? And they're usually a little bit more reluctant to that, and so the reciprocation of that is, of course, you understand that I'm going to have that same permission so that I'll be able to speak to your wife if I feel, your spouse, if I feel that he or she is not being effective. Well, they like that part a lot better, and so they'll always pretty well give
It's a
permission.
tit for tat.
You know.
So in the meeting, do you actually say that? You say, excuse me,
Absolutely.
you're not being effective?
Or develop, some clients are not receptive to that kind of a direct, I've had clients say, well, maybe you could just give me a hand signal or kick me under the table or tap me on the shoulder or, just hold your hand up. It's whatever the client is comfortable with if they're not being effective, because they want to be effective. What's their goal? Settlement, right? They want to get there. And yes, they're going to give you permission because they want to do that. They want to be effective. They want to get there in the shortest path possible.
Part of your preparation, by the way, and you'll see this when we get to lawyer meeting, is an opportunity to have canvassed from the other lawyer what they anticipate or what their client anticipates may be the problem. And so you will have a better sense. Some people are getting divorced and they have really nice ways of communicating with one another, so you don't have to beat this thing to death. But I think it's more prevalent than not that one of the persons is very disrespectful in the way they speak to the other party, either always have been or it certainly developed since the separation. And if you know that in advance, then you tailor, we talk about this stuff with everybody, but you might emphasize privately with your own client before you're going into these meetings, even more so, how important it is to be effective. Like, you don't want to be on your client's back exactly, and making them alienated.
It needs to be respectful.
You have to be respectful of them. But I think you can do that in a way by making it in their interest to do it this way. You want to be the most effective. You don't want to waste money on these things. Clearly, we don't want to be speaking to the other person, and we always put it the other way too. We don't want the other person to be viewed this way. You can be assured that they're hearing that from the other lawyer and so on.
Common ground rules.
And even you can be very respectful by saying, it's not uncommon, or we commonly see when people get down and sit together, that even though when you and I talk, we can talk very respectfully to each other, and you can speak respectfully of your spouse. When we've seen this, we've all seen this. You go into a meeting and this person turns into whatever the other, is it Mr. Hyde is the bad part? Whatever. Anyway, and they just are transformed. I've had friends who I've acted for who have been totally transformed in a meeting, and they turn into like truly ugly people. And if you're normalize that by saying it's not uncommon for people under the kind of stress that you're under to suddenly act out of character and be. You may actually know the person is always an asshole, but in actual fact, you don't tell them that, and you have to deal with it in such a way that you can during the course of the meeting intervene. Let me just jump ahead to another technique that I think is very important and probably self-evident to you. If someone is not being effective in the meeting, who ought to raise that? Who ought to raise it in the meeting? And you do this, by the way, in front of everybody. So you've got to be somewhat careful that you're not getting the guy so angry at you that you're making effective. I've kind of given it away, haven't I? Yeah. Pardon me? The own lawyer. And this is why you deal with these files with people who have the same understanding of the process as you. You should be able to expect that the other lawyer will deal with these things. Now, for my money, I certainly don't jump on the first time anybody sort of slips. You have to do.
It's a balancing act.
I'll just tell you a quick story. You'll hear about this file later probably, but there was two people here that were at our thing last night. But for the first group, but Janice and I fairly recently took on a file that, I haven't counted the numbers, but it's between 30 and 40 interim applications have been made by 2 previous lawyers. It's just outrageous, and
They don't have anything.
there's a history way back of like drug abuse and all this kind of jazz on the one part, but and we really anticipated when we took this one. We said, okay, this will challenge our theory that we can take any file and do it collaboratively. We've had our second meeting 2 days ago. I have to tell you that this is one of the smoothest so far, but it was really funny. The first meeting we went to, one of the rules we have, and it's not one of the big rules, but we say one of the things about speaking respectfully is that, you know, you should not refer to the other person as she or he. They have names, and
That's not
it's
polite.
just slightly disrespectful. I mean, it's not like you don't know the name. You know, it's really, and the guy was talking.
My
And
client.
we were well into this. I acted away. And we were well into this, and he started to go, shh. And he looked quickly at Janice, big smile, and gave the name. And everybody looked at one another because we
We
knew
kinda all
exactly what had
chuckled.
happened there, you know? And it was just kind of one of those moments, and it was a small point. I guess we had to be there to appreciate it. But you realized that this guy was well briefed, he bought into it, and it was going to go really well. And I have to tell you that the conversation between these 2 people who have been fighting for
Almost
2.5
2 years, more than 2 years, I guess now.
and about like everything.
Vicious litigation. I mean, as vicious as it can get.
That
Allegations
it's as
of
smooth-
all kinds of.
It's as smooth as any we've had
Yeah.
so far. I mean, we're keeping our fingers crossed. We haven't really crossed the Rubicon yet. But it is strictly a question. We both spent a ton of time with these folks,
Up front.
telling them, coaching them as to how they ought to communicate. So just this number 4, everybody understands that they don't respond well to being accused, and so it's again a question of putting the person in the other person's shoes, which you'll hear about when we develop options 2. And commit to the fullest development of choices and alternatives. And this is difficult, I think. Again, it's not uncommon. It was a problem that was again raised last night by some of the folks in the first group that have been working at this for a while. What happens when people think that they've got the solution and they want to deal with it right away? You want to get that commitment up front from them that they will be patient and that they will try to develop more options than just the one that comes to mind first. How about this one? Okay, let's sign it, let's go. And that's very important.
One of the ways we can deal with that is by saying to our clients, we know this process works as lawyers. We are committed to this process. We know it is effective. We have a track record of being effective. Even when you're beginning, you know it anecdotally from our group, from the existing group that you're going to be going into. And that if you do the negotiation up front, it's much more likely to fail, and is that what you want?
That you can say to them, look, this may be the solution in the final analysis that you'll come to anyway, but, again, going back to what Noel said before, there are other possibilities probably out there that you haven't canvassed yet. Why don't we spend some time, some money, talk about this stuff a little bit more widely. It's in your interest to develop, in your self-interest, to develop as many choices as possible. You may find that you'll get a deal that you will consider to be a better deal if you spend a little bit more time on this. And the other thing is you really want to, sometimes there's one person that's particularly impatient and you've really got to keep them under, convince them that it's in their interest to allow the other person the time that they need to see that all of the options are developed for to their interests. 6 is just say no, and Janice talks about people having a yes and a no button in these things. And I think that one of the concerns that people often have in this process is that they will not, or that they will be inclined to accept something that they really don't want. Because here they are, they've got these lawyers here, and they've got that person sitting across, and they're just going to cave, and they're going to fold. And I think that we have to emphasize with them that it's on them. And then I'll just digress just slightly. One of the things that's extremely liberating for lawyers in this, and this is why I particularly like this process, is that once we get over the hump of us being the people who make the solutions, of us having the answers.
Control.
Control, exactly. You know, it's really quite interesting. You have particularly female clients come in and they say, I've got this terrible husband, he's a controlling bastard, and I want to get rid of him. Now, would you take this problem from me and tell me what I'm supposed to do? And you're going to, you know, he's replacing one controller, the husband, with another controller, the lawyer. Which is, I always kind of find this amusing. They don't see it quite that way, but anyway. What we're trying to do here is we're trying to say that these are not our problems. We ought not to be the ones that go home and can't sleep at night. So from a selfish point of view, that ought to be the case. This is not our problem. And we have to convince these people, our clients, that this is their problem. It will remain their problem, and they will solve the problem. We will help them do so. We don't have all the answers. We have a lot of experience, or some experience, or you know, we read a lot, or whatever our line is, and we can help them develop some options. But we want them to do it.
We will be their guides, but they will make the decisions.
To give them the opportunity to pass it on to us, we are doing ourselves a serious disservice from a selfish point of view, right? Why should we be doing that? And not only that, if we've got a couple hundred files, how much weight of the world can you carry anyway?
And who are they unhappy with when the solutions are not perfect?
If you convince them that it's their problem, and which it is, you're doing a great service to them as well. Because they are often functioning at a very low level at that time. And by empowering them to get back up and work on these problems in an active way, you are actually doing them a big favor. Because the sooner that they're up and operating and able to make decisions, sometimes they're making decisions about things that they've never had to make decisions before. Spending money, making money, you know, that kind of thing. Parenting that they haven't had to decide about before. And for them to sort of lop off the problem and be able to walk off and say that this is the end of the story. This is for them. You know, it's my lawyer's got the problem, and I feel so much better now that I've talked to him or her. Here's a little thing that we use. It's a little not timely anymore since Princess Diana's been dead for 4 or 5 years now. But you've got this. It's either a bad cartoonist or a good rendition of an extremely unattractive woman. Holding the Princess Diana thing and the beautician saying, did someone change our sign outside from beautician to magician? And frankly, this is what happens with a lot of our family law litigation clients. That's what they want. They want a magician. They don't want just to help someone to help them solve their problem. So I think that this is very liberating for lawyers.
David, I'll just give you one example. A file this week that was supposed to go to trial and settle. And last time when you took the training with Kevin and the others a couple of weeks ago, they talked about the lawyer being the rescuer and the rescuer's dilemma. It was a classic. The other lawyer promised the moon, the sky, and the stars. There was a chambers motion. We hit the press in July in this file, and they were going to rescue the client from all of their troubles. The client gave them $5,000. Fast forward 5 months later, the lawyer has quit. The client has a $5,000 bill to the lawyer. And all of a sudden, all she can talk about to our client is what a terrible person their former lawyer was. They've moved from rescuer to persecutor. So their persecutor now is no longer my client, but their former lawyer. And it happened in 5 months. And it was just a perfect example of what exactly happened. So it's a well-known persecutor in town.
Oh, okay, that guy. So the other thing is effective. Be
We'll
effective.
talk about that.
Did we? All right. And then be empowering. Take responsibilities for your feelings, your interests, your choices. Essentially, that's what we've just talked about as well. So these are, if you're having problems with people not, sort of not going any further, not going anywhere, you pull these out and read some of this stuff, and you can go back then to first principles. Like, remember when we talked about, when you first came, talked about this problem, how you have to be effective. You have to empower yourself. And you can just go back and repeat these kinds of things and then give them some ideas about how they can do that.
So really David is saying is that when you reach impasse, as we all do on files, that going back to process anchors, going back to first principles, going back to fundamentals, what's laid out in the contract, the interests they've identified, the process anchors, That's the solution to impasse, is going back to the foundations. And that's, you're going to hear that theme repeated through this next day and a half.
And I think you know that you are getting more comfortable with the process when you see impasse as a challenge instead of as a, oh my God, what do we do now? And that will come.
Impasse is where we do our best work, and it's most exciting, and it's most creative, and it's most rewarding. That's where we get our best kicks in collaborative
You crank it
as
up.
lawyers, where we really, you know, the rubber hits the road where there's impasse, and that's, I mean, ask Murray as a mediator. I mean, what are your most satisfying files?
The ones that give you the most challenge.
Right.
Most difficult.
Right. And those are the ones that we're most creative, we do our best work, and that's most exciting and most rewarding.
If you do mediation, and at the end of the mediation, you say, I don't have a clue why those people are getting divorced. That has not been very challenging, you know?
It's too easy.
Yeah.
Yeah, and also kind of disappointing.
Yeah. We want to move quickly through using questions. Again, another theme you're going to hear is that while we think we know the answers, we're asking you as lawyers to let go of your instinct, which is to assume you know what's best for your clients, and to be the naive questioner. That's a fundamental skill to collaboration, as it is in mediation, to be the naive questioner, to be the naive person who really, naive curiosity. That's a theme throughout this.
This overhead should be at your materials. It'd be the second page behind tab 5, I think.
So these are some examples, because this is your fundamental tool in your toolbox is using questions and using them effectively. And that's a very big shift outside of the adversarial toolbox, which is telling, giving advice. So we're taking out of that and moving into using questions as tools. And these are a whole range of suggestions for you. Types of questions that you can ask. And you may say, you know, gosh, you guys, you've got 3 pages of different kinds of questions. How will I ever take all of these on? How will I ever manage to know when should I use a creating doubt question? When should I empathize with a question? When should I ask questions that are educational or reality checks? When do I use these questions? And the only thing I can say to you is use the cheat sheets. Write them down. Take these with you. Use whatever crutches you need, and believe it or not, they will come. You will begin to use these, and they will become second nature. I mean, Murray, when you started out doing mediation, did you have all the right questions? Did you have all the right tools? But did that stop you?
No, and I mean, I can't speak in the collaborative law model, but at least in the mediation model, I don't know if I ever always have all the right
Exactly.
tools and all the right
Exactly.
skills, but
You just try and do it better each
yeah.
time.
It's exactly the same, and frankly, the questions that you ask as a mediator are the same kind of questions that you ask here in collaboration. And we don't want, this is not, if you're not a mediator, you're screwed. This is really easy once you get this stuff. It's all here, and practice will make you not
Better.
perfect ever, but it'll make you better. But I don't know if we've used this term, naive curiosity.
Yes.
This is something that we will repeat from time to time. And sometimes when you're doing this stuff, you'll think to yourself, my God, they must think we are really stupid. You know, you're asking a question to which the answer may be obvious, but in actual fact, the obviousness will become evident when they answer. So when they answer, the idea is to get them to state something which will make them realize what they had just said or what they're just proposing may or may not work. Okay? Usually it's not working. I'll give you an example of questioning that works in that regard. You get a guy who works on the rigs, and he's gone 3 weeks and home for 3 weeks, and he insists that he should have custody of the 18-month-old daughter. So you ask him, what would his day look like?
What would that look like?
What would that look like?
Tell us about your plan. What would your plan look like?
What you've got to try to do, by the way, as a lawyer, what your immediate reaction is, that is one of the stupidest things I've ever heard. You've got to put that
That'll never
aside.
work.
It may not be, in actual fact, is one of the things that we're increasingly learning. But let's assume that you've still got that at the back of your mind at the very least. What you want to do is not tell him that it's a stupid idea, even if he's your own client. One of you should be asking him, how would your day look?
In
What
a
are you gonna
respectful
do?
fashion that doesn't ask the question in a fashion that puts them down.
And so, and just spend some time dealing with that. You know, he's got this idea, he's going to have his mother look after the kid, or he's going to have the nanny, and what's that going to cost, and how that, is that worked into your budget, and you know, and all this kind of stuff. And where will mom be when you're doing this? You know, she's sitting at home knitting or whatever, but she won't have the kid. You know, that this is, and you know, most people come fairly quickly to a realization.
These are
well,
reality
maybe
check questions.
Maybe there are other options, you know.
These are the different forms of questions that we've been able to distill. Open, closed, focused, directed, and undirected. So we'll leave those to you for your reading, and we know that these are not things that you will instantaneously use comfortably, that they take a while to bring into your toolbox of using, but that they are fundamental to this process, and you will find them easier to use if you could make the shift inside your own head of being the naively curious person who is truly interested in what's behind the behaviors, what's behind the interests, what are the motivations, what are the whys behind what's important to your clients. And, you know, we've spent so long, many of us who are a little grayer and older, in the telling, that that's the critical shift for us as lawyers, is to move into, why do you think that, or why is that important, or can you tell me about what that means, even when you think you know. And one of the things I've learned is that in the last year and a half, I have learned more from my clients, and I have learned more about what's important to people and what's reality about justice, and I have learned more of that from clients than I have ever learned in the previous 24 years. That our clients have more to teach us than we have ever given them credit for, and we will never learn those things if we don't open up our minds to figuring out what makes them tick and what motivates them. Because this isn't about us. This is about them, and the adversarial system is about lawyers and judges. It's about us. It's about our egos. Collaborative law is not about the lawyers. It is about the clients. We're going to show you before lunch, because we're all sort of winding down into a need for food, so this will be perhaps a little less demanding. We're going to show you a videotape of John Haynes. He is one of the most skilled mediators that we have ever run across. Back in 1987, David and I did our initial mediation training with John. John died 2 years ago. He is one of the most skilled questioners in terms of using the naive curiosity and the naive questions and the different forms of questions. And we're going to show you a videotape of John with Norman and Terry. And it's called Who Makes the Decisions Here? And this is John with 2 clients. And while you watch this, please look at what John's doing and pay attention to the questions, not necessarily the solutions, or we're asking you to watch this for the types of questions, the forms of questions that we've just briefly reviewed with you.
I don't think so. The other thing to watch for is the way in which he asks. He's so respectful of people when he does this stuff. Is he okay?
Hello, I'm John Haynes, and today I'm going to be working with 2 people who've been sent to me by the local court system. It's Terry and Norman. Terry is an advertising executive, a very successful professional woman. Norman is an aviation consultant and also very successful in his field. They've been divorced now for 3 years. They share the custody of their daughter Susan. Susan spends 1 week with Terry and another week with Norman, rotating back and forth. They each live in different parts of Edmonton. Susan is now age 6 and will be entering public school in September, and so there's an issue for the parents to decide which school district she should live in, because now it's time to change that original arrangement. And apparently, each of them wants Susan to live with them during the whole of the school year. So the judges sent them over to me to see if we can work it out in mediation. Well, good to see you both. As you know, I've seen your folder here, and I've gotten just the barest of details from it. I've really not read all of the reports and that have been compiled over the years, because it seems to me that it's most helpful if I put that down and ask you to tell me what the situation is. And let me see if I understand correctly. The real issue between you is how to reorganize the parenting and the residency of your daughter, Susan. So why don't you tell me what the situation is? Perhaps if you could begin, Terry, and then I could ask you to tell me your position, Norman.
As you know, John, my ex-husband and I are having difficulties regarding what school Susan's going to go to. There is a school adjacent to my home in Edmonton that is a very liberal thinking school and has very liberal teaching philosophies. The school is modeled along the lines of the open classroom, and it provides an enriched environment that I would dearly like to see Susan attend.
Mm-hmm. I see. And so you'd like her to live with you while she's during the school week while she's attending the school?
Yes, I think that that's only fair. Okay. It's close to the home.
Mm-hmm. Okay. Thank you. Norman.
Well, I think that Terry's use of the word school is a more generic one. It's not really a school in my estimation. It's more of an elevated game preserve for children. It is very progressive. I give her that. It's unstructured, no curriculum and all that sort of thing. But I want my children to get back to the basics and have a broad experience with every walk of life, kind of people. I don't necessarily want an urban brat. And, you know, we've had 3 years to think about it, and I guess what's happened in the intervening 3 years is our expectations have been individually developing.
Let me interrupt you for a second, Norman, because I wasn't quite sure that I understood. What is it that you would like for Susan?
Well, I live on just the fringe of town. I live on a beautiful sprawling acreage, and there is a school district within a very short distance of our home. When I'm there, I can drive. If not, there's a bus system very nearby. And it will give a very broad human experience to the children. There are, sure, there are rich kids, there are the yuppie kids, but there are farm kids, there are whites, blacks, oriental, the whole experience. And that, frankly, is what I want for my children. That's what I had. Dr. Haynes, I'm a self-made man, and brought up in a small town. My father was a miner, and he gave me the basic opportunity to, have an education and so on. And I have succeeded, not that Terry hasn't, but I feel that I've gone up through the ladder, and I've been a better person for it.
Okay. All right. So the one difference between you then is sort of a philosophy of education, that you'd like Susan to go to the school system with an open classroom and a philosophy.
John, if I can interrupt, it's not a philosophy of education, it's a philosophy of living. Terry is an urban snob. I want my children to learn, for example, that this isn't money, this is money.
Okay. All right. So there are other issues between you around bringing Susan up?
Yes, as Norman has most pointedly indicated, our philosophies of life differ quite substantially. Norm feels that because he had to work for everything that he has obtained in life, that our children must do the same thing. And I would like to see our daughter have some of the things in life that both Norman and I weren't able to have as children by virtue of our family circumstances.
Okay. So I guess that was probably one of the reasons that you ended the marriage, was those differences in terms of how to approach things. Okay, all right. And the struggle here today is to see how to organize the best for Susan so that you can have a good parenting relationship with her, Norman, and you can have a good parenting relationship with her, Terry, right?
That's correct.
That's the goal.
I think so. In the last 3 years, joint custody has been fine. I mean, it's allowed both of us an opportunity to preserve our relationship with the children. And that's fluffy and all the nice things that really strokes Terry. But it's time to get down to basics.
Okay.
I don't care if the children are musically inclined and realize themselves. I want them to read.
Tell me a little bit more then about the geography, because I need to get that understood now. You're in the school district downtown?
That is
And
correct.
you're in the school district in town?
On the fringe of
On
town.
the fringe of town.
Yes.
And what's between you?
The city.
So, can you see a couple of questions that you can identify so far in this? Question forms. How's he asked questions?
Open,
Yeah?
refocus.
Yes, he's done some refocusing. He's done some normalizing questions. He just did that just past when he basically said, he's acknowledged that there was a marital fight, that it's unresolved past, he's closing it out and moving into defining terms of parenting, the parenting issue, schooling issue. He just did that. So he's got some normalizing questions going here. He's got refocusing, reframing. So those are the kinds of techniques that he's using that we'd like you to continue to look for.
Rich and
How about school systems? I'm not...
Well, I believe that there's another school somewhere in there. I think
He's
we live,
fact
what, about
gathering
15
right
miles
now.
apart if you
Uh-huh.
had to measure it out.
where the crow flies.
Okay,
But,
so it's about 15 miles apart, and you've got currently you live in two different school systems, and there may or may not be a third school system between you. Okay. Let me ask you a couple of questions so that I can understand. What do you know about the outcome of your respective school systems in terms of number of kids who go on to college, for example, or the grade levels? Do you have any ideas?
Well, I can tell you about the school system in my neighborhood. I've investigated it quite thoroughly, I think. It's a rather new school. It's actually physically an older building, but the school has been revamped. It's designed for an open classroom kind of setting and an enriched program for children. Susan would be attending school with children of her own socioeconomic background, which I think is very important.
Okay, I'm sorry, Terry, I lost you somewhere there. You were telling me about the outcomes of the school system.
Yes.
What kind of results they have.
Well, the
Isn't that
results
nice?
are not yet known because this is a new philosophy of education that has been put into what used to be an inner city school.
I see. Okay.
they're still in the guinea pig stage.
Yeah.
I really resent that one.
What's the
There's such
outcome?
an urban snob, it makes me want to throw up.
Yeah,
I'm
what's
so
the
tired of this
outcome
self-made man
of
stuff.
Your product, your school system.
Well, the children, again, it's difficult to tell because we're talking about elementary school. But I can tell you the children don't just wear pastels and skip to school. There's a good mix. They don't all expect, to have alligators on their sweaters. There are plaid shirts, there are ski sweaters, there are t-shirts, there are no shirts. There's a broad mix of experience, race, color, creed, socioeconomic categories. Now, I would suggest that once the children evolve out of this elementary school near to my home, they're necessarily funneled into, the cosmopolitan kind of school system of the Edmonton Public School System. And it may be that the children will ultimately be destined, to Strathcona Composite or to Harry Ainley or the like. And at that stage, their individual likes and preferences and all that sort of stuff can be accommodated. But at this stage, the school Harry's suggesting is close to the university,
Okay,
is
I lost
experimental.
you again because you were going to tell me about outcomes of your school system.
Well, statistically, I don't think we can suggest the success rate in going to college and that kind of thing, because it is an elementary school after all. But the natural progression would be that you'd have good, rounded, athletic, scholastic children out of my school that I'm proposing, funneling into the Edmonton public system and being assimilated by the system, excelling if they're disposed to, and not if they're disposed to.
Okay, let me ask a couple of other questions. You must forgive me for jumping around because I need to sort of get an overall picture in order to be most helpful to you. But Terry, tell me a little bit about where you live.
Well, I live in an apartment building, actually. I occupy one of the 3 penthouses on the 32nd floor of an apartment building in the city. It's spacious, it has a beautiful view of the river valley. It's very central in terms of its accessibility to theater, the art gallery, those types of places.
And it requires its own life support system.
Okay, great. Norman, what about your living situation?
I'm on an acreage, as I indicated. There is all of the kinds of amenities that children would otherwise have to look for in the city, and there's a swimming pool there where my children, the neighbors can come over and play in the pool. I have lots of room for any of the athletic, pet kinds of activities that Susie wants to get involved in. So it's got everything for them. It's got the mix of accessibility to the city, but the rural experience as well, and not necessarily having to be condemned to the lemming-like
I
hysteria
get
of the
the
city.
view that you both enjoy where you're living now.
Absolutely.
Oh,
And
definitely.
you both enjoy the time that Susan spends with you.
Susie, yeah.
And I get an idea that Susie enjoys the time she spends with each of you.
Absolutely.
And so in a sense, she's getting the best of two worlds. In the sense of your rural living and the expansiveness and your urbane
Well, John, I gotta stop there. I'm not sure she gets the
etc.
best of both worlds in Terry's environment. I think she gets the best of both worlds in the environment that I find myself in. There's a proximity to the downtown, proximity to all of the arts and all that sort of stuff on, a peripheral menu basis.
I would assume that's another disagreement that you have between you as to whether or not that occurs, right? I'm just hearing from you, Terry, that she gets the best from your setting in terms of its urbanity and its availability to the art and theatre.
I
etc.
believe so.
And I hear from you, Norman, that she's getting the best in terms of the space and the homogeneity of the area, etc.
Yes.
Okay. All right. Okay. We've now collected the basic data. We have a sense of what perhaps the issues might be. And I'm beginning to develop a hypothesis in my mind as to what is happening. In the next part, I'm going to test out that hypothesis and see as I do that what you think is going on and see if you can develop a hypothesis about it, and we'll check back a little later. Okay, you've both now given me some important material and background. It's clear that you have some differences between you as to the kind of education that would be best for Susan. That you have a different lifestyle and you've some different philosophies about life in general. But clearly, you've both been very successful in your own way. You're very successful in advertising, Terry, and you're very successful in aviation, Norman. So you've both got success behind you, and I'm sure that you'd like to pass that success on to Susan. And so I suppose the issue is how can you get to Susan what she wants and needs, what you each want and need, in a way that meets your needs and her needs. Your needs and her needs in that sense. So let me ask you now, if Susan wasn't in the picture, would you still be living just where you're living now?
Most probably. From my point of view, where I live is very close to where I work. I work long hours. It's important for me to remain fairly central so that I don't spend a great deal of time commuting to and fro as I would were I living where Norman lives. That's very important to me. And therefore I think I would still be living in the same place.
Okay. All right.
I enjoy the rural flavor, the rural experience. I mean, it goes back to my childhood and so on. if I didn't have the responsibility associated with my job and you know, responsibility financially and otherwise for my child, I suppose you dream about opting out of the system and really doing the rural experience. But realistically, where I am now serves both my needs. My need to be mobile on a sort of an extra provincial basis. I can fly out of Edmonton to where I am needed in relation to my consultation and consulting business. Yet I have the rural experience. So I guess, yes, of necessity, where I'm at is a compromise. I need to be near to the city, but it allows me the rural experience.
Okay.
So, he talked about his hypothesis. Any idea what his hypothesis was and what his questions elicited? He's drawing out interests here, remember. He's looking for interests. And he asked the parents about if there was no Susie, where would they live? And what did they tell him?
They live in the same place.
Whose interests are those? So his hypothesis perhaps was this issue about where they're living is about the interests of each of the parents and not about Susie. It's their individual interests, not Susie's interests, that's focusing them on where they're living. And that was his hypothesis, and he's using those neutral questions, the naive, be curious questions, to test out his hypothesis, that this is drawing out the interests of mom and dad. Or is it Susie's interest? Is it something that they feel is important for Susie that she live? Or is it really what's important to them for themselves? And what did he find out? His hypothesis was correct. And sometimes we will find that our hypothesis is not correct.
What do you do on the week when Susie is not with you?
Really little different than what I do when she was with me, except perhaps I try to schedule more of my out of the city kinds of activities. My job is such that I can, with a pretty fair amount of accuracy, plan my trips to, you know, San Francisco, Montreal, wherever I have to go in relation to my contracts. And it's convenient for me that when I have Susie, I am on site in town, working out of the home, working out of the small office I maintain. When she's not with me, that's when I plan my transit.
Okay. Okay. How about you, Terry? What do you do when Susan is not with you?
My life is pretty well the same as it is when Susan is living with me. Of course, the activities may change in the sense that when Susie's with me, I spend more of my free time involved in activities that she is interested in.
Okay.
But apart from that, my day-to-day schedule or routine remains pretty well the same.
Okay.
Shopping alone, shopping with Susie is all the same.
I really resent that.
Let me ask you, do you travel out of town all the time?
Occasionally. The occasional convention elsewhere.
Okay, all right. Does it ever happen that you have to travel out of town during the week that Susie is with you?
Very rarely. That has occurred on occasion where I am delayed, and generally I can usually get a hold of Terry or have West Edmonton Mall page her or something, get a hold of her.
Listen, I earn my own money, and I really resent you telling me how I should spend it.
I was so interested, so that if Norman gets hung up out of town, then Susan stays with you and there's no problem in that?
No, we've managed to work that out.
Okay.
That was certainly, I mean...
So there's a lot of cooperation between, there's a lot of digging back and forth, but there's also a lot of cooperation that goes on between you around.
Of course, Susie is the focus of our lives, I think.
You can be rest assured that if it weren't for Susie, we wouldn't be seeing one another.
That's for sure.
Yeah, that's for sure. Yeah. You fight a lot as ex-wife and ex-husband. But
well,
you seem to cooperate as
ex-wife, yes.
You seem to cooperate as parents of Susie, it seems to me. Yeah.
Well, we like to think that we have her best interests at heart.
Yeah. All right. I'm going to ask you each to do something a little odd, which is now, assume for a moment that, Norman first you, and then I'm going to ask you, Terry, but assume for a moment that you decided that Susie was going to go to school in Terry's school district. How would you like to organize the time? And then I'm going to ask you, Terry, to think about if Susie lives with Norman to go to school in Norman's school district, how you would like to organize the time. Okay?
Well, I suppose what you're asking presumes that for the sake of convenience, the child would be living with Terry while going to school.
During the school week, yes. You're obviously going to have
That's
every one of you during the school week, right? You've got really two options as I see it. You can both live in the same school district, and then you could maintain the current arrangements if you could live within relative close proximity. Or,
Would you move?
Would you?
You're renting, I'm owning.
What's that got to do with it? I'm settled.
the issue is I suppose, it's a fair question to ask. It's an answer that you should each give, or both give possibly, which is would you be willing to move to the same district in which Susan lives?
Well, a move for me is completely out of the question. I have very, very bad allergies to pollen and animals and that kind of thing. So moving out of the city and living on an acreage is completely out of the question for me.
Oh, I'm sorry, I misasked the question. It wasn't necessarily that you would move to where Norman lives, or Norman that you would move to where
I understood what you're saying.
Terry lives. You might both move to somewhere that's sort of in the middle. That's an option. You really do have options here.
Or I suppose a child go to school in the middle. If not,
Well, that doesn't really solve the problem, though. What it
well,
means
it does
is
from the standpoint that the child goes to school, and in between the two of us, we can maintain the schedule we've already established.
maybe so, but we both end up being shuttle buses is what it boils down to.
Mm-hmm.
No skin off my nose, I shuttle down.
Besides, we don't know anything about this abstract school district somewhere in the middle. You know, I've investigated the school district that I would like to see
Right.
Susan go to.
When you forget your humble beginnings, when your family moved into Edmonton off of the farm, your parents were damn glad there was a school within a 4 or 5 block radius of your home, so you could walk to school. They weren't too concerned whether or not all of the teachers had PhDs, or whether the children were being videotaped during play therapy and all that sort of stuff, and when they make building blocks. They were glad there was an school where there are humans going, you know?
Times
reading, writing,
have
arithmetic.
changed, Norman.
Now you have to have something where the children are rendered into a laboratory slide and examined every day.
Norman, you
So
don't know what
there's
you're
a school
talking
in
about.
between the two of us. It's got teachers, it's got kids. I don't think there's any downside to it.
Norman,
It has possibilities.
apart from the basics, which I am assured that Susan will get at the school that I have looked at, there is also the Enriched program that will foster her musical talents, and you're very well aware of those musical talents. And as well, this particular school is experimental, and I'm particularly caught up in the idea that
They certainly are.
the school promotes critical thinking in children. They don't accept everything carte blanche as you do.
The difference is they may know how to think critically, but unhappily when they have to read, they have to hire someone, which is consistent with your lifestyle and your theory.
I'm assuming that you really both want what's
Mine
best
teaches
for Susan,
self-sufficiency.
right? You both want what's best for Susan, right?
Yes.
You may think that that best is a little different. You may define it differently one way, Norman. You may define it differently another way, Terry. But you both want what's best for Susan, right? So let's see what we got here. In essence, we've got a situation where, Terry, you live in one school district, right? And along with that school district is a whole living situation in the apartment and downtown and all the things that you want. And Norman, you have another school district and that you live in, and with that is a living situation in terms of the acreage and the... Okay. Now, within the school system then, you have here essentially an open class philosophy, which you believe will foster her intellectual development and critical thinking. And in your system, you have a basic and heterogeneous population that will foster her basic ABCs and also give her an exposure to a wide range.
That's right.
Okay. Now, if Susan lives in this school district, then she has to live with Terry during the course of the week to go to school there conveniently, right? If she goes to this school district, then she has to live with Norman during the week in order to be able to go to that school system conveniently. Third possibility is now emerged that perhaps there is another school district within reasonable proximity that perhaps you might each be able to travel to. Or it may be possible for each of you to move to that same school district and live within some proximity. So that perhaps it might be that you could live on the east side where there was still essentially easy access to the urban aspect, and you live on the west side where there was easy access to the rural aspect. And
I'm not sure moving our residences is functional or realistic. I'd be more inclined to explore whether or not the child could be enrolled in that third school district, and we rotate, we accommodate that. I'd be open to that. I'd compromise to that situation, because my notion is it's not going to be this goofy, prepubescent wild kingdom that happens in this experimental situation. I think it's a bit more of a compromise towards your basic 3 R's.
And you'd be willing to give up Susan going to school in your school system if you could both agree to a mutually acceptable third school system?
I'd have to look at it very, very hard. Thinking ahead here as you've been going through the flow chart, I simply am not prepared to relent to Susie going to Terry's environment. Apart from the philosophical problem I have with the teaching, I feel cheated. Why have we gone through this joint custody thing for the last 3 years, which has been, tantamount to time sharing, when suddenly, hey, the child's gone all week long, and I'm going to be put back in the role of an accessory parent. Maybe weekends, but not every weekend, because I'm sure Terry won't.
Okay, don't worry about you being cheated. Make sure that Susan doesn't get cheated. Right? That's
Well,
the critical point here.
Let's look at it reflexively.
Hold it there for just a second though, Norman. Terry, what's your view on this?
Well, I agree with Norman in that I think it's unrealistic for us to relocate our residences to this hypothetical third school district. I would be prepared to continue with the same residential arrangement, 1 week with me, 1 week with Norman. However, I would want to look at this other school and satisfy myself that Susie was not merely going to get the basics, the 3 R's. I want to see her in some kind of an enriched program. I think she's an intelligent and creative child, and those areas ought to be fostered at a young age.
So you'd like her to have a good basic education plus the additional enrichment that would meet her particular needs?
Oh, definitely.
And
I think she'd be bored in a school system in which she would receive merely the basics.
And that, from your perspective, Terry, that if that could be obtained, that you would be willing to think about the third district and give up the idea that Susan would have to go to your school district?
Yes.
Okay. So now you both agreed, right, that you would like to look at the possibility.
It's not going to happen. Unless the kids learn math in a tutu, she's not going to be happy.
Norman, how can you say it's not going to happen? You don't know. Always jumping to conclusions.
Norman,
Well, my problem is there's a built-in problem here. She said I have to look at the school and satisfy myself.
let me interrupt here, okay? Because it doesn't help me to understand to be most helpful to you if you each speak a lot for yourself. And so it doesn't help me for you to say to me, you think whether or not you think it will work from Susan's perspective. It does help me if I understand whether it will work from your perspective.
I am prepared to say carte blanche that that third school district is not, to the extent that it's not the experimental school that Terry's university laboratory class is, I will go for
Don't tell me what
it.
it's not. Tell me what you want. You want a school system, and let's just list that it has the basic 3 R's, right?
Scholastic
Scholastic
Athletic.
emphasis.
and extracurricular, the
Okay.
basics.
Okay. Athletics
The things that made Terry and I both,
and
the successes we
extracurricular
are in
activities.
16.
Okay.
That's it.
Okay. Terry, what do you think you would need in that school system?
Well, as I indicated, what really caught my attention about the school in my own district was the open classroom setting that fostered the critical thinking skills.
Okay.
It wasn't rote learning.
Can I
Okay.
ask you something? You didn't know what a Chablis from a Bordeaux until we started making bucks. Okay?
Let me-
You never appreciated the opera until we started making bucks.
Excuse me, Norman, I'm just...
We have
I'm
to give
lost
our
here.
child the ability to make the bucks so that he can begin.
Terry-
Norman, shut up.
Terry, you're telling me that you want a system that teaches critical thinking? What else?
I wanted to foster an appreciation for the arts, music, dance, those kinds of things.
Okay. All right.
BMWs.
Norman, read.
Now, it seems to me then that if I understand lots of school districts, that the list that you have here in terms of having a good basic education with scholastic emphasis, athletics, extracurricular programs, an ability to foster critical thinking and have available arts and artistic programs is all possible within one school district. Huh?
Well, I don't know, the public school system here. I'm not so sure.
Okay. Well, my assumption is they're going to the public, she's going to the public school system in either case, right?
Yes.
Okay. You're both going to keep her in the public school system.
You bet.
So that really we have to look at what's available in the public school system. Now I wonder whether you'd like to now spend between now and next week looking at those systems around you that are within reasonable geographic proximity of each of you, so that obviously you can't, we have to set a maximum mileage that you would have to travel. But you would look at those to see whether or not they meet your criteria, Norman, and they meet your criteria, Terry.
Well,
You have to go together.
I was about to suggest that we do. After all, this is our child, and this seems to be about the only thing we have in common.
Okay. It's also the only thing you have left to fight about, too, so... How would you like to do that? Would you like to go together?
I was going to suggest that perhaps we could arrange a mutually convenient time to meet with the principal of the school or someone else who could explain the facilities and the programs to us.
Let me suggest this then, that you both do that. If you both feel that the school meets with your approval, then you really just need to call me and tell me. And I can then draft you a quick memorandum and send it back. If you disagree, then you can come back and we can look at it again from that perspective.
Okay, that's agreeable to me.
Okay,
Can we bring some of the materials back to you if we can't agree?
Oh, absolutely.
Because,
Absolutely.
again, forgive me, but I just think that this, we're going to break down. And I
Knock
think we
it
need an
before it
objective.
begins. It will break down if you let it break down. It will break down if you let it break down. But if you don't, and if you don't, it won't break down. It's up to you, not up to each other, up to you. You can't control anything that Terry does. You can control what you do. And therefore you can control that part. And you can't control anything that Norman does. You can control you, and you can control that part. If you focus on that piece that you can control, you don't have to worry about it falling apart, because you'll make it work. You're both very powerful people. You'll make it work if you want to make it work. If you don't want to make it work, then you won't. But if you don't want to make it work, be responsible yourself for it. Don't look to the other one for it. So in the course of the next week then, go look at the school. See if it meets your criteria and your criteria. If it does, then we can simply continue the current situation and Susan can go to that school. If it doesn't, we come back and look at it afresh with all of that new information. Okay?
Okay.
Good. So you'll call me, say,
balance of it is setting up the next meeting if they need it. So that is an example of a very skilled mediator who is dealing with a fairly high conflict situation and parents who are taking a lot of shots at each other, that there hasn't been a lot of preparatory work done in terms of them coming into the mediation, in terms of respectful behavior, in terms of good communication techniques, ground rules. They've come in cold. John's done a mediation with them on a single issue. And I would, one observation I would make in terms of what we see in our collaborative files is that with the preparatory groundwork that we're going to get into this afternoon in terms of the initial interview, the groundwork with the client's pre-meeting, the groundwork with the other lawyer pre-four-way meeting, and what we do in the first four-way meeting, that rarely do we see that level of conflict expressed in those ways. It surfaces now and then, but we don't see a consistently high level of that kind of conflict.
And the other thing is, you can see how much easier it is if you've got two people and two facilitators, two lawyers, and each of them have responsibility, if you wish, for one client. And so the mediator isn't struggling with, or the one person isn't struggling with trying to keep each of them on the straight and narrow without insulting either of them.
Being neutral.
You've got your own lawyer who's going to bring you under some rein. So it really it moves along in a much more orderly fashion, a little less conflictual fashion. Because you've got that.
The methodology he used, now I realize there's time constraints because it was a video, but wasn't it he who suggested the possibility of a school in the middle? And is the mediator properly to give the potential solution?
Well, I think he did it quickly. He did it more quickly than you would normally want to see, I think, in a mediation or a collaborative process.
Right.
But we're not just there to do nothing. I mean, we do help with them with the development of choices. Now, you might do it more effectively or more appropriately with a lot of questions, so until they finally come around to it. But if you've got some ideas that they haven't got to, and you haven't been able to develop them through questions, though you've made a good effort to do so, and I think you want to get those options out there too. You've got four minds working on the options, not just two.
And I guess I would share Noel's criticism, which is I think the basis of his question, is if this is truly a client-controlled process, that was very much not coming from either of the clients. And I realize there's the time constraints, but that is something we'll have to guard against in collaborative law, which is I've got the cookie cutter, and let's get it into my cookie cutter solution.
The purpose of the video, though, was to show you some techniques where he got them back on focus, for example, and he was particularly good at that, I thought, just kind of ignoring some of what they said. And I misstated the question, which of course he hadn't, just to take some responsibility and to get them back on. But I agree that there's a real problem with